Thanks very much, Mark. In contrast to what you've just heard from Dean, I'm going to talk not so much about how immigration authorities are becoming more police-like, but about the way Australian police at times actually use immigration law as a resource to achieve their policing objectives. I'm going to use as a metaphor, just to frame my comments today, the idea of crimigration. Some people think that's an awful word. The idea was articulated by US legal scholar Juliet Stumpf in about 2006 to encapsulate what she saw as trends in the United States in which criminal and immigration law were really starting to merge in all sorts of interesting and sometimes disturbing ways. So as I say, it's just a metaphor for me today. I'm not going to go deeply into Stumpf's arguments. I'm going to talk about the ways that New South Wales Police reported to me using immigration law to resolve problems of crime and disorder. So very much pursuing, traditional policing objectives, but with immigration law playing a role. I'm going to use material from the two studies that are on the slide there. The first is actually a study that very much echoes what Dean's just told you about his work in the UK, where I was looking at the networking of immigration authorities in Australia and how they brought other agencies into their immigration control work. So that study is not directly about crimigration, but I think there are some interesting observations I can make based on that data. And also just passing reference to an ongoing study that I'm doing with Sharon and others on deportation in Australia. I'm not sure if I have to point it there, but that seems to be working. Okay, a really good example, just to get the idea of crimigration in your mind straight off. An example that all the Australians in the audience will immediately relate to is the calls for deportation of protesters following the recent clashes in Sydney. The so-called Muslim riots. Very quickly, the Immigration Minister, Chris Bowen, and so I'm noting here it's politically driven. I'm not suggesting this is driven by police at all. Chris Bowen moved very quickly in the public domain to talk about deporting those who were involved. At the same time, a lot of rhetoric about them being pure criminals, criminality. He talked in one breath about the protesters being pure criminals, and in the next breath that deportation would be the response to that. So a clear conflation of the ideas of criminal process and immigration. I found from my discussions with police in New South Wales that they were involved in a really wide range of immigration enforcement related activities, which are on the slide there. Much of it having very little to do with traditional concerns about public order and crime control. So unlike British or American police, Australian police are really deeply integrated into immigration enforcement. I think this is somewhat of a colonial legacy. I need to do the sort of historical work that Dean and Mark do to unpack that. But they're designated officers under our current legislation, the Migration Act. They theoretically have all the powers of an immigration officer, although of course they don't use them all. They're empowered to check immigration status. There's a special system set up by the immigration authorities called the Immigration Status Service, the ISS, which is there for police to make checks on people's immigration status. They're required by law to detain people if they suspect they do have an unlawful status, even when there are no criminal matters involved. So police are very much immigration enforcement officers in Australia. I'm going to concentrate today on two arenas where criminal and immigration matters could overlap in day-to-day, everyday policing, so the white points on the slide, and consider how police resolve dilemmas that occur there between the competing imperatives of criminal prosecution or administrative removal under immigration law. So the first of the white points, police in their day-to-day activities reported to me that they encountered people who turned out to be unlawful non-citizens in various contexts, and a small proportion of those will also be people against whom criminal prosecutions could be brought. So criminal suspects who police encounter who are already unlawful non-citizens is the first and biggest category. And secondly, I'm going to make a few comments about a much more, I think, infrequent occurrence where police may play a more active role in actually constructing illegality of criminal suspects who are not already unlawful. I hope that will become clear. So speaking first of all about identifying people who already have an unlawful status, in interviews, senior police very often spoke about, used the phrase getting rid of people. They talked about getting rid of people in the circumstances that I've got on the slide there, where they considered the offence was not a serious one or where they had doubts about the capacity to convict. The third point is an interesting one, although I'm not going to elaborate on that today. It's not really the choice of police in that circumstance. There were occasions where it was almost like it was a race against DIAC, against the immigration authorities, for the police to make sure they got hold of people for prosecution before they would disappear in what was at the time a very well-oiled kind of deportation machine. Funnily enough, by the time I interviewed people in the late 2000s, I was also getting complaints the other way around, that what had previously been a system that worked well for police if they wanted to get rid of someone, that usually they could be dispatched fairly quickly. A lot of extra due process checks came in, and changes in policy came in after 2007 with the new government, the Labor government, but also the falling out from the Palmer inquiry, which some of you might know about, you know, all the revelations about the deportation of Australian citizens, Cornelia Rao, Vivian Solon, led to greater checks and balances. So we get the story both ways. Sometimes criminal suspects or witnesses that the police want would disappear too quickly if they didn't take the right action. At other times, police complaining that it all happened, there are too many barriers now to get rid of people. Okay, so just so that you don't think I'm making this up, this idea about police being prepared to have people removed if it's not too serious an offence, or if they don't think they've got a chance of conviction, I'm just going to show you 3 or 4 quotations from senior police. You'll see from this one, it reflects a very pragmatic kind of approach, getting people out of the community one way or another, and using immigration law very much as a resource. A second example, sorry, a bit more to read there. Similar rationale really underlying that statement by a different senior police officer, explaining a little bit more that administrative processes are quicker, they're cheaper, rather than going through prosecutions, and also telling us that they happen often, it happens all the time, and can be considered a satisfactory solution for a policing problem. Another very similar kind of statement, but this time really making the point that removal in some circumstances can count for police as the best result that they can achieve in a certain circumstance. So very much a problem-solving sort of attitude being taken. This is the last long quote that I'll make you look at, but so these calculations are caught up, not unsurprisingly, in the expectation of what will happen in court. Police are often, I guess, required to make those kinds of speculations. But this statement, interestingly, raises the point that in turn, police perceive that courts are taking into account immigration outcomes. So immigration law even becoming more and more embedded in the court process. That's something I haven't studied myself, but I'm just interested to see that that's what police are perceiving. And certainly there were lots of statements about the court process being seen as, the prosecution process being seen as fickle, as being too lenient, or being a riskier proposition, and so perhaps alternatives being looked for. So this frustration with recidivist offenders or troublemakers who were seen as not being dealt with satisfactorily by the courts seems to have led some police to dig even more deeply and proactively into the resources that are offered by immigration law. So note here in this statement that the informant is talking about people on visas, not people who are unlawfully present, but people who are on visas but are not citizens and are therefore liable to cancellation of visas on character grounds under Section 501 of the Migration Act. So we're moving on to that second point of where police become involved in visa cancellation. Okay, this is a very highly publicised case. Sydney siders would have been aware of it, perhaps not others. In about 2008, at the time that I was conducting the interviews, doing the research, what caught my attention about this case was statements that were attributed to senior police, including Andrew Scipione, not on this slide, but others, endorsing visa cancellation as a very effective strategy for securing local crime control objectives, and appearing to suggest also that this would become a strategy that would be used more in the future. So I tried to discuss this a bit and probe this in interviews, actually quite often stepping over the mark of, you know, good research where you're not supposed to lead. I really wanted to find out if this was becoming more prominent strategy for police. One of the issues about this that seems crucial to me concerns the scope of the power to cancel visas, and that extends beyond the immediate criminal conviction to consider patterns of past offending, perceptions of future offending, so we start to get sort of future crime coming into this, but also conduct other than a conviction. This opens up all sorts of new arenas. These matters were carried considerable weight in the case of Maria and Prince Brown, which I had on the previous slide, in looking at their appeal cases, both of which failed before the Administrative Appeals Tribunal and then later before the Federal Court. Although each of them had convictions, also it was obviously decisive in the reasoning of both courts that police were able to put forward evidence of a pattern of ongoing suspected criminal activity and an expectation that they would continue to behave this way in the future. It also, I think, very importantly brings criminal intelligence into playing a very important role. So criminal intelligence played a major role in these administrative appeals in a way that where it was not tested in the court in assessing what the future behaviour of these two were likely to be. So some very interesting things from a legal point of view. Okay, I'm just going to quickly give you that in case people like to sort of know the law behind things. You don't need to read it all yourself, but I can just summarise for you that this character test under the Migration Act includes past and present criminal conduct, past and present general conduct, not necessarily associated with criminality, and also what I think is important is the test applies to people whose applications to come to Australia might be refused on character grounds, and the same test, at least as it's stated in law, applies to people who might have been living in the country for a very long time but whose visas stand to be cancelled. So that seems a problematic sort of construction for me. Going to move on now to just try to make some evaluative comments about this. I've really only sketched it out, but I'll try and consider what this might all mean. I don't want to say too much about the first question about usefulness because I have no data about it really. Police clearly, when they spoke to me, really believed that it was a major coup to have removed very troublesome people from the community, and in the appeals for Maria and Prince Brown, police cited evidence from the community that they were pleased with the police action in this case. The research questions that I'd raise if I were going to look into this more carefully would be, what would be the longer term effects of relying on removing people out of a community where there is an entrenched problem. Maria and Prince Brown were accused primarily of drug dealing, and so does removing individual people necessarily in the long term completely overcome the problem. And also, and I think more interestingly from this talk, since this is a transnational measure to deport people on the basis of their character, returning someone to a country that they may have left any number of years ago and for any number of reasons, you do need to consider the displacement effects at a transnational level. So I think it really opens up a whole other arena that is often not considered. So Ben Bowling, who's been mentioned a couple of times in his recent book on policing the Caribbean, talked about the problems associated with large-scale deportations that were happening from the UK back to Jamaica of Yardies and various people involved in the drug trade, both in a minor and major way. Problems in terms of their reception in the community, and also the Jamaican government not being too pleased about this either. So we have a whole other transnational dimension about displacement that we don't usually consider in our paradigms. So the second question, how widespread are these policing tactics? I only have really indirect information and anecdotal about this. I conducted a survey with operational rank and file police in New South Wales and asked them, in the last 5 years, do you think you've been involved more or less in immigration enforcement? It came out pretty much that about half said that they thought it was about the same, but when I dug more into their own backgrounds, I found that more long-serving officers were more likely to say that they thought immigration related activities were increasing, so that's just some information. Certainly highly ranked police believed that there was a growing awareness, they were in specialised roles so they probably would know about these things, of immigration options that would be open to police, and not least because of proactive efforts of the immigration authorities of DIAC to promote their immigration status system, which I mentioned before, where police can check people's immigration status system through training. They were rolling out training at the time I was doing my interviews, and embedding liaison officers in Sydney also. So Sydney is a very big user of this immigration status system, about half of the calls in the data that I was given. And this is also reflected, this proactive role for DIAC, for the immigration authorities, reflected in the statement by this manager that suggests that DIAC are wanting to see more and more embedding of questions about immigration status within police systems. Okay, as for the last point on cancellation of visas, I have no time or 1 minute. 1 minute. 1 minute. Cancellation of visas is not happening at a high rate in Australia. And I really can't say whether it's going to be become a common policing tactic. In the words of one informant who did speak specifically about this case, he believed that was driven, the police action there was driven by, quote, sheer frustration and also involved some local political pressure. So we don't know that police are the main drivers of this. One thing that's notable, though, about the character removals is that in the Federal Court and Administrative Appeals Tribunal, for the Brown case, it came through very clearly that, in fact, the ministerial directions that govern visa cancellation condone deportation being used as a legitimate mode of deterrence. The statement from the AAT decision says, quote, while visa cancellation is not intended as a punishment, paragraph 2.11 of the direction contemplates that the prospect of it will operate to deter similar conduct in much the same way as the threat of punishment does. So this is a very surprising to me embedding of crime control goals within immigration law, and seemed to be acceptable, was accepted by both the AAT and the Federal Court. It may also explain why senior police in the media that I mentioned earlier around the Brown case talked up the use of this strategy of cancelling visas in a way that doesn't seem to be backed up by how much they are using that strategy. So, of course, talking up is often a part of a deterrence-based strategy. So I think I've shown you some examples of how migration law is becoming embedded in police practice. I won't have time, I'm afraid, to consider what I think of the social implications. I'm not advocating as a great strategy for police. I'd like to talk about what I think is sort of a problem with that.